we have some important news about the current efforts to remove suppressors and short-barreled rifles from the National Firearms Act across the country. This comes after the new tax change that reduced the NFA tax to $0. The Trump Department of Justice and Attorney General Bondi are continuing to defend the NFA, and now all the major anti-gun groups have joined in to support their position. They're all arguing that the NFA should still remain in place. Let's talk about what's happening in this critical case. Before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. You can also turn on all notifications because that will help ensure you get these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, they're in a league of their own. They're backed by an actual law firm called Attorneys for Freedom, and they're always expanding their benefits to give you as much as possible as a member. One of the new things they added is they're guaranteeing 4 attorneys to your self-defense case. If you're interested, check them out using the links down below. And if you use my code, ARMSScholar, you can get $25 off your sign-up plan. As I mentioned in the intro, we need to talk about what's happening right now in response to H.R. 1, the big, beautiful bill, and the recent changes to the NFA tax. The tax went from $200 to $0, which is now in effect. In response to this new change, multiple Second Amendment organizations have launched challenges and lawsuits to try and remove all the remaining restrictions on short-barreled rifles, suppressors, any other weapons, and all the other items under the NFA. They're trying to use the $0 tax as a way to get rid of all the NFA restrictions. Recently, you had groups like Gun Owners of America, the Firearms Regulatory Accountability Coalition, Silencer Shop, a bunch of other companies, and then also 15 states that joined together to file a lawsuit against the ATF. Then there's another case that we're going to be talking about in this video, which was filed in the Northern District of Texas. That case is called Jensen versus the ATF. This case was assigned to a very favorable judge named Matthew Kacsmaryk. You may remember that name because Matthew Kacsmaryk has issued some very favorable Second Amendment rulings in the past. He's issued rulings against the ATF's pistol brace rule, the 80% receiver rule, and a lot of other ATF overreach cases. Recently, the plaintiffs in this case filed a motion for summary judgment with the ultimate goal of ending the remaining NFA restrictions sooner rather than later. In this lawsuit, the plaintiffs argue that since there's no longer a tax on these items like suppressors, short-barreled shotguns, any other weapons, and all these other items, there's no longer a valid constitutional basis to further regulate them under the NFA. This position is actually opposed by the Trump administration, and now multiple anti-gun groups have filed a brief in support of the Trump administration in this case. That, of course, is not a great look for the administration when you have essentially every major anti-gun group in the nation supporting your position in a Second Amendment case. In this lawsuit, the plaintiffs argue that suppressors are protected arms and that they're used for lawful purposes. They state in their case that a suppressor is a safe, effective, and commonly used device that decreases the noise level of gunshots. Suppressors improve the experience and use of firearms. They decrease the risk of permanent hearing damage, help protect the hearing of hunters and those nearby, reduce noise pollution from firearms discharges, make firearms training safer and more effective, and increase the accuracy and ease of use for those firearms. They also argue that short-barreled rifles are protected arms and they cannot be classified as dangerous and unusual items. This, along with the fact that the big beautiful bill has now eliminated the tax on these items, means that the remaining NFA restrictions on those items should be struck down. They argue that the NFA's registration and related requirements on untaxed firearms exceeds Congress's enumerated powers and are thus unconstitutional. In summary, what the plaintiffs asked for in this case is for the court to declare that the NFA's registration and transfer requirements pertaining to all of these untaxed items goes beyond Congress's enumerated powers. They asked for the court to stop all of the ATF's employees and agents from implementing or enforcing the NFA against all of these untaxed items. That is what this lawsuit aims to do in response to the NFA tax change that is now in effect. Now the plaintiffs are asking for Judge Kacsmaryk to grant a motion for summary judgment in their favor. In this case right now, they argue that since there's no longer a tax on these items, the NFA's restrictions must be struck down. They argue that a full trial is not actually needed to rule in this case. The Trump DOJ has also responded by opposing the plaintiff's motion for summary judgment, and they argue that Judge Kaczmarek instead should grant them a motion for summary judgment, essentially rule right now in their favor. In the brief, the DOJ argues that the NFA remains fully constitutional despite the new $0 tax change. According to the DOJ, the plaintiff's core premise is completely wrong. They argue that the NFA is not untaxed. They state that while the making and transfer taxes for items like suppressors, short-barreled rifles, and any other weapons was set to zero, they argued that Congress explicitly preserved the NFA's special occupational tax on manufacturers, dealers, and importers, along with the entire registration and approval framework. Separately, the DOJ contends that even if the taxing power were somehow insufficient, the NFA is independently justified under the Commerce Clause and also the Necessary and Proper Clause. Those arguments are echoed now by the anti-gun groups who have filed a brief. Groups like Brady, Giffords, and Everytown all joined together to file a brief in support of the Trump administration and their position that the NFA should still remain in effect. In their brief, the anti-gun groups argue that the NFA was lawfully enacted and remains constitutional because it targets a narrow category of weapons they claim are uniquely dangerous. They argue that Congress acted within the Commerce Clause and its taxing powers to address public safety concerns and the risks to the public which are tied to firearms that are concealable, that are reduced in detection, and that potentially have increased lethality. These are all things that these anti-gun groups are arguing in regards to suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons. According to them in their brief, these items are not ordinary firearms, but tools historically associated with violent crime and shootings, and Congress therefore had a rational basis to regulate these items through the registration and federal oversight that was put in place by the NFA. The brief also defends the NFA's registration system, arguing that it does not ban these items, but instead allows for lawful ownership only while you are complying with the NFA. They claim that the ultimate goal and positive aspect with the NFA is that it reduces criminal misuse. The groups claim that the registration, background checks, fingerprints, and ATF approval improve traceability, discourage illegal purchases, and prevent the illegal making of these items, and also prevents illegal markets. They further argue that Congress's 2025 decision to reduce the NFA tax and turn it to zero on certain items does not invalidate the law completely. They claim that lawmakers intentionally preserve the registration system and other regulatory requirements under the NFA. In their view, the NFA remains a valid comprehensive regulatory scheme that Congress may enforce still to ensure the effective national control of these items. There are a lot of moving parts right now when it comes to this NFA battle. But again, it's not a great look that you have the administration making these arguments in favor of the NFA. And then you also have every major anti-gun group who has jumped in support of that position, and they're arguing against the Second Amendment. That's especially not a good look when you have the administration claiming to be the most pro-Second Amendment administration ever. But then you are arguing in favor of the NFA, and then also every anti-gun group has jumped in support of your arguments. Again, not a great look for the administration. This is a case I will especially be keeping my eyes on because of the jurisdiction of this case, and also the favorable draw of the judge, Judge Kaczmarek, who has issued some very solid pro-Second Amendment decisions, especially decisions against the ATF. That's what's currently happening in this critical NFA challenge. As we get more information as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. It tells the YouTube algorithm that you appreciate these types of Second Amendment videos. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.